Welcome and thank you for joining part 2 of Seyfarth's PAGA webinar series, What Remains in the Wake of Viking River Cruises. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature located on the right side of your WebEx window. We will do our best to get everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the presentation. At this time, I'd like to turn the program over to Andrew Paley.
Good morning or good afternoon, depending on what time zone you're in. And thank you for joining us today for our discussion of the Supreme Court's recent decision in the Viking River Cruises cases. As I'm sure many of you have heard, the decision fundamentally changes the landscape in California with regard to the ability to compel to arbitration PAGA claims on an individual basis. Before going any further, I'd first like to introduce our panelists for today. As Christian mentioned, I'm Andrew Paley. I'm the chair of our California Wage and Hour Practice Group. And with me today are two of my partners who have a wealth of experience defending clients in PAGA litigation, Beth Pelliconi and Michael Afar. During today's presentation, we will first recap the holding of Viking River and explain the basic parameters of the court's rationale. We'll then get into a discussion of the application of Viking River to some of the most common versions of arbitration agreements and touch upon how you may wish to modify your existing agreements to make best use of the decision in Viking River. We'll then also cover what aspects of the California Supreme Court's decisions in the Iscanium and the Kim versus Raines cases survive the U.S. Supreme Court's decision in Viking River and what the landscape looks like post-Viking River, and then finish up with a discussion of what we think the future holds with regard to PAGA litigation, along with what the responses we're seeing currently out of plaintiffs' counsel to the decision. As Christian mentioned, if there's time remaining, we will attempt to answer as many questions as possible. So please feel free to submit any questions that you have using the Q&A button on the lower right-hand side of your screen. With that, I will turn it over to Beth to kick us off.
Thank you, Andrew. Here's a brief summary of the facts and procedural history from Moriana v. Viking River. Moriana was employed by Viking River and had executed an agreement to arbitrate any dispute arising out of her employment. The agreement contained a class action waiver providing that there was no right to bring a class, collective, representative, or PAGA action. Moriana filed a PAGA action against Viking River, alleging individual as well as representative PAGA claims on behalf of other aggrieved employees. And Viking River then filed a motion to compel arbitration. The motion to compel arbitration was denied by the trial court, and that denial was upheld by the Court of Appeals. The trial court and Court of Appeals had concluded that Moriana could not be compelled to arbitrate her PAGA claim under the holding of iscanium v. CLS Transportation, Los Angeles. That holding barred contractual waivers of individual and representative PAGA claims on grounds that individual PAGA claims cannot be split from representative PAGA claims. Viking River then filed a writ petition with the U.S. Supreme Court. The Supreme Court reversed the Court of Appeals decision and found that the Federal Arbitration Act preempts iscanium's rule that PAGA claims cannot be divided into individual and non-individual actions through an arbitration agreement. Because the court found that individual PAGA claims can be split from representative PAGA claims, Viking River was entitled to enforce the agreement to the extent it required arbitration of Moriana's individual PAGA claim. The court also held that under PAGA's standing requirement, plaintiffs can maintain representative PAGA claims only by virtue of also maintaining an individual claim in that action. That means once an individual PAGA claim is compelled to arbitration, the employee lacks standing to maintain a PAGA representative claim. And the court also found that a waiver of representative PAGA claims was still invalid under iscanium if construed as a wholesale waiver of those PAGA claims. So this aspect of iscanium was not preempted by the FAA. The severability clause in Moriana's arbitration agreement was key to the court's decision. A severability clause allows a court to sever unenforceable provisions of an agreement and apply those provisions of the agreement that are enforceable. As the court held under iscanium, the lower courts were required to treat the wholesale representative action waiver as invalid, but the severability clause allowed enforcement of any portion of the waiver that remained valid. Therefore, because of the severability clause, the agreement still permitted arbitration of Moriana's individual PAGA claim, even though wholesale enforcement of the waiver was impossible. There was a troubling concurring opinion by Justice Sotomayor in the Viking River decision suggesting that there may be changes to PAGA standing requirements in the future. In the concurring opinion, Justice Sotomayor noted that once a plaintiff's individual PAGA claim has been compelled to arbitration, the plaintiff could not maintain a representative PAGA claim at all because of statutory standing requirements. Justice Sotomayor warned that the court's understanding of state law may be wrong and that California courts would have the last word on this issue. She also suggested that the legislature is free to modify the scope of statutory standing under PAGA, and these comments essentially invite changes to those standing requirements under state law. Going forward, the Viking River decision means that arbitration agreements which provide for waivers of representative PAGA claims are enforceable. Arbitration agreements that provide for waivers of individual PAGA claims are not enforceable. And arbitration agreements should contain severability clauses to avoid wholesale rejection of the agreement in the event a court finds that it contains unenforceable provisions. Back to you, Andrew.
Thank you. So what we'll now do is take a look at some of the more common variations of arbitration agreements that we've seen out there and talk about how they fare under Viking River. We can go to the next slide. So the first scenario is you have an arbitration agreement that has a blanket waiver of PAGA claims, but it also has a severability clause. This is, as Beth noted, the scenario that the Supreme Court faced in Viking River. And so the result there will be what we've seen in the decision, that the individual PAGA claim, or frankly, more technically accurate, the PAGA claim that arises out of the employee/private attorney general's alleged labor code violations, that goes to arbitration. And all of the non-individual component of the PAGA claim, the part of the PAGA claim that would apply to any of the other supposed aggrieved employees, that should be dismissed because the employee now lacks standing to pursue those claims in court. Second variation, you've got an arbitration agreement that states that all disputes between the employee and the company shall be resolved purely on an individual basis, and specifically states, including all PAGA claims, and that the company and the employee agree that the employee, if she seeks to be a private attorney general, shall only pursue claims on behalf of the state with regard to supposed labor code claims that affected her. Essentially, this is a situation in which the employee agrees to limit the definition of the supposed aggrieved employees to just her own fact pattern. Before Viking River, this would not have been an enforceable clause. Post Viking River, this is enforceable. Result is the plaintiff can only proceed in arbitration with a PAGA claim based upon her own individual fact pattern and nobody else. And here, it's important to note that you don't need to rely upon the severability clause. If you've got one, that's fantastic. As Beth pointed out, having the severability clause is still a good thing, but here you don't need to rely on it because the agreement itself is that the employee will only pursue claims purely on an individual basis. Next slide. So those are these examples. Now let's talk about a couple of other things that examples of arbitration agreements that we've seen. Some of the older agreements, especially ones that were put into place shortly after Iscanium came out as a reaction to the language in Iscanium, expressly excluded PAGA claims from the scope of covered claims in the arbitration agreement. Those types of agreements are going to be problematic in the context of Viking River, because here Viking River wouldn't apply because the agreement contractually has already excluded a PAGA claim from the claims that the parties agreed to send to arbitration. So the result there is going to be that the plaintiff is going to be able to proceed with the full scope PAGA claims on behalf of, for example, all non-exempt employees in court. So if you've got that type of an agreement, that's definitely one that you should consider modifying. Next scenario is a little bit of a twist on the prior one. So the arbitration excludes PAGA claims from the scope of covered claims, but it says to the extent required by law. Well, okay, so based upon Viking River, what does that mean? Well, according to Viking River, the claims that cannot be covered, arguably, are the representative element of PAGA claims, but the individual PAGA claims can be covered, and therefore the result should be the same that we saw in Viking River, that the employer should be able to compel to arbitration the individual claim, and thereafter the remaining claims should be able to be dismissed because the plaintiff lacks standing to pursue them. Next scenario, the arbitration agreement is silent with regard to representative actions or a PAGA waiver. So this is an interesting one. It doesn't say anything with regard to PAGA. It simply says that the parties agree to pursue claims on an individual basis in arbitration. So here, under prior Supreme Court jurisprudence, the Stolt-Nielsen and the Lamb Plus cases, the result should be that the same as in Viking River, that you should be able to compel the individual claim and the representative claim should be dismissed. But the rationale is a little different. That now is based upon the fact that the parties never agreed to any sort of a representative PAGA claim in arbitration. Next slide. So now we get to one that's a little tricky. So you've got an arbitration agreement it contains a blanket waiver of all PAGA claims, and there's no severability clause. So this is a little different than what was presented in Viking River. Here, the outcome's a little bit more unclear, but given the hostility that California courts have shown to at least pre-Viking River of arguments with regard to PAGA claims, this one potentially is going to be a problem. So we know, based upon Viking River, that the blanket waiver of all PAGA claims is invalid, but you still, even without the severability clause, could potentially make an argument that the court should blue pencil the PAGA waiver out of the agreement and excise that portion, and then still send the individual portion to arbitration. The question there, though, is will the court do that? Or will the court say that the blanket waiver is an integral part of the agreement, and therefore it's not going to exercise discretion to blue pencil it, and frankly, then invalidate the entire agreement? Obviously, there are no decisions on this issue yet. Viking River is only a week old, but this is at least a potentially problematic clause. And so if that's the way that your arbitration agreement is written, this is another one that you should probably think about making some modifications. Next slide. So let's switch gears a little bit and talk for a moment about is there anything about iscanium that now survives Viking River? Next slide. It's important to remember that Viking River only applies to arbitration agreements covered by the FAA. So there are certain agreements that are not going to be governed by the FAA. For example, there are categories of workers in the transportation industry that are expressly excluded from the scope of the FAA. In that regard, just recently, the U.S. Supreme Court issued a decision in the Southwest Airlines versus Saxon case dealing with baggage handlers, finding that they were involved in interstate commerce and therefore were expressly excluded from the FAA. So if you happen to be in one of those industries, Viking River is probably not going to provide you with a lot of comfort. The next point to remember is that if an employee didn't sign an arbitration agreement, then Viking River is not going to apply, even if most of your other employees did sign arbitration agreements. It only takes one employee who hasn't signed an arbitration agreement to still have the ability to seek to be a private attorney general and pursue claims with regard to all non-exempt employees. Another thing to bear in mind is that even if your agreement is enforceable, there's the possibility that we may start to see mass individual PAGA arbitrations. There are, to be blunt, the Plaintiffs' Council isn't going to go away. They're going to look for new creative avenues. And Michael will talk a little bit more about this in a minute. But something to just keep an eye on is whether or not we start to see more mass individual arbitration cases being filed. In that regard, another thing to keep to sort of look at that we really can't get into a lot of detail today is whether or not you can insert into your arbitration agreements some sort of poison pill language with regard to mass arbitrations. If that's something that's of interest, please reach out and we can discuss that separately with you. So that brings us to whether or not you should revise your arbitration agreements post Viking River and or roll out a mandatory arbitration program if you don't already have one. The wild card here is that the Ninth Circuit's decision with regard, in the Bonta case, with regard to mandatory arbitration programs that supposedly finds that asking employees to sign a mandatory arbitration agreement is unlawful, but if they in fact sign an arbitration agreement, then the arbitration agreement is still enforceable. One of the strangest decisions we've seen in quite some time. That decision is still, en banc review of that decision is still pending, and we're waiting to see what the Ninth Circuit does with that. So that still clouds the landscape. Next slide. At this time, I will read out the CLE code. It's SS, as in Seyfarth Shaw, so SS 3683. Again, it's SS 3683. I will, at this point, turn it over to Michael.
Thanks, Andrew. Next slide, please. One of the sort of best takeaways from the Viking River decision was an implicit overruling of the Kim v. Raines decision. And it's something that I think we're going to see a lot of, at least in the short term, as employers try to use Viking River as a sword, not just to compel claims, individual PAGA claims to arbitration, but also to the extent employees have already released or given up their individual claims to then preclude them from having standing to pursue PAGA claims otherwise. The California Supreme Court's decision in 2020 held that under PAGA, an employee did not lose the ability to pursue representative claims as an aggrieved employee just by virtue of settling and dismissing individual claims. However, that decision from the California Supreme Court in Kim v. Raines appears to have implicitly, if not explicitly, been overruled by Viking River. The direct quote is on the screen in front of you, but some of the key language is where the court said when an employee's own dispute is paired away from a PAGA action, then PAGA does not allow such persons to maintain suit for purposes of standing. And even though Viking River was in the context of an arbitration agreement and individual PAGA claims being compelled to arbitration, we think that that sort of rationale should still apply in the context of Kim v. Raines and any sort of other agreement to dismiss individual claims, whether by settlement or an arbitration agreement. Next slide, please. And just from that rationale, Viking River must trump Raines on that point of standing. The concept being that if you no longer have standing to pursue your individual claims, you should no longer have standing to pursue representative PAGA claims, whether, again, that's by an arbitration agreement or an individual settlement. Of course, the big question mark behind all of that is that is the state of the law right now after Viking River, pending any sort of changes from the California legislature or the courts of appeal that say otherwise in terms of what standing actually is. One other recent case in California that's caused some headaches is the Johnson v. Maxim Healthcare decision that came out last year, which held that employees who otherwise would have been time barred on their individual claims can still pursue representative PAGA claims. Viking River didn't expressly touch on that issue, so you could potentially see a situation where you have an employee from 2, 3, 4 years ago outside of the ordinary one-year statute of limitations on a PAGA claim who never signed an arbitration agreement, trying to come forward to still represent individuals despite their own individual claims being time barred. Again, we think that Viking River should still control in that situation because if the employee doesn't have individual standing in this situation because of a time barred issue, then they shouldn't have standing to proceed on a representative basis as well. Next slide. And so the biggest question mark right now that a lot of employers have sort of been waiting around to see what's going to happen, and again, it's only been 1 week since the decision, but Justice Sotomayor did warn that the Supreme Court's decision in Viking River was based on their understanding of California state law on the issues of standing at this time, and that the California courts will ultimately have the last word on it. There was also a hinting that in terms of standing, the California legislature would be free to modify the scope of standing under PAGA, and whether that ultimately would be reviewed again by the United States Supreme Court is very, very unlikely. And so it's safe to say at this point that any changes that come forward from the California legislature or the Court of Appeal will likely be the nail in the coffin in terms of what standing will look like for these types of claims once the individual claims are pared away. The preview is to either go through two routes. One is through the legislature. As it stands right now, the 2022 session of the legislature will be ending in August of 2022, but the deadline for any bills to come out of the House of Origin ended in May. So effectively, there's nothing that's going to come out this year that could potentially undermine what Viking River held for standing purposes. But it's very likely that there will be some attempt to address those holes in the 2023 legislative session. We've already seen one state senator, Dave Cortez, out of San Jose, who indicated recently to the Daily Journal that he plans to pursue legislation that follows the guidelines in Justice Sotomayor's concurrence. And so it previews the importance of taking advantage of the Viking River decision now, at least while there is a short-term lull in any action from the California legislature to get those PAGA claims dismissed in court after they're potentially compelled to arbitration on the individual side. With the appellate route, typically that takes longer just to get a case to go through the Court of Appeal and have a court address that issue. But there are situations that could have that happen even before the legislature does have a chance to act, whether that's by a Court of Appeal that could potentially have a similar issue in front of it right now, asking for additional briefing, or a question being certified to the California Supreme Court by the Ninth Circuit, and potentially being fast-tracked on those grounds to answer that question, given its importance to California's attempts to enforce their own labor laws. Finally, as Andrew mentioned earlier, even though it's only been about a week, we have seen somewhat of a reaction from the plaintiffs' bar in terms of what they might be doing for next steps. Most that we've seen are declining to move to arbitration voluntarily, even in light of Viking River and in light of arbitration agreements that are identical to Viking River, or would be a situation that it should be compelled in some of the examples that Andrew framed earlier. Some other plaintiffs' bar members are raising a poor argument about defendants having waived their right to compel arbitration, which is ridiculous given that the right to compel the claims never existed prior to Viking River. We suspect they know that these arguments are incorrect, but they're doing it for a procedural purpose, which is to force defendants to move to dismiss these claims or to move to compel arbitration of the claims, and then they'll appeal. The plaintiffs' bar will ultimately appeal those claims, and in the interim, while it's pending before an appellate court, they're hoping that the California legislature or California Court of Appeal will act in a way that will undermine Viking River and fill in those voids suggested by Justice Sotomayor, so that ultimately there will be no impact of the Viking River decision on their cases. Next slide. So we're just about at our time, but I think we might be able to answer a few questions that we've gotten. Andrew, I don't know if you want to take it away.
Yeah, let me, I think we'll see if we can try to get to a couple of questions. We have a few questions that are similar. Let me try to just group these together and paraphrase. So there are a couple of questions here with regard to why is it, or why are we saying that it's the case that if you have an employee who didn't sign an arbitration agreement, that they would be able to pursue a full scope PAGA claim that covers potentially all non-exempt employees if other people did sign arbitration agreements. The answer to that lies in the fact that PAGA is fundamentally different than a class action. So if we were talking about a class action, the answer would be very different, because in the context of a class action, if an individual employee signs an arbitration agreement, then the court lacks jurisdiction over the individual's labor code claims. That's not the case in the context of PAGA, because the real party in interest in PAGA is still the state of California. And as Viking River explained, what you're really looking at in PAGA with the representative nature of it is really joinder of a lot of different claims in which the real party in interest remains the state of California. And so the fact that you've got other individuals who have signed agreements isn't going to preclude the individual, or at least arguably isn't going to preclude the individual who has sought to be a private attorney general from representing the state with regard to these other actions, because there's no limitation on that person acting as the state. Let me quickly see if we can hit one or two others before we run out of time. So we've got a question here with regard to, I think this is an interesting one. So with regard to independent contractor agreements, can you insert an arbitration provision in an independent contractor agreement that would preclude a representative PAGA claim with regard to misclassification? Michael, you want to touch on this one?
Yeah, I mean, I think in terms of the independent contractor stuff, and you know, looking at that, I mean, we would certainly want to make sure we would treat it the same way that we're looking at it. I mean, even if a court were to hold that any of these individuals could be deemed employees, the provisions would still apply. And so we'd want to make sure that we've got arbitration provisions that are still following all the same, you know, suggestions and holdings of Viking River.
So we're now sort of just out of time. I realize that there are still a number of more questions here. So what I would encourage people to do, if we haven't been able to touch upon your question because of time, I apologize, but please feel free to reach out to any of the panelists. Our information is on the screen, or any other Seyfarth attorney that you might be dealing with directly on these issues, and we'd be more than happy to address any other questions that you have on these issues. Thank you so much for attending, and have a great rest of the day.